Welcome to day 3 of the CNTA conference. Shortly, you'll hear from Dr. Richard Martin about the right to take resources in the Gurtja people's native title claim. Dr. Martin is a socio-cultural anthropologist in the School of Social Sciences at the University of Queensland. His research focuses on the politics of land, identity, indigeneity, and development in Australia. Dr. Martin works in the Gulf country of Northern Australia on a range of academic and applied research projects, continuing to develop friendships and collaborations with Indigenous and non-Indigenous people in the area. Dr. Martin was the lead anthropologist for the Gurtja people's native title claim around Normanton, which was litigated in 2019 and addressed issues of succession and the right to take resources for any purpose. One final point I'd like to remind you of, which I'm sure you're all well versed in at this point on day 3, but could you please use the Q&A function rather than the chat function to ask Dr. Martin any questions? And you can use this throughout the presentation. You don't have to wait till the end. So over to you, Dr. Martin. Thank you.
Great, thanks very much for the introduction, and I will share my screen with you. Which you should be able to see now. All right, so I'd like to talk about the Gurtja people's claim, which was a native title claim that, as Josh mentioned, was litigated in 2019. And the expert evidence was actually heard in the last days before the lockdown of 2020, early 2020. So luckily we got it out of the way. And the Gurtja native title claim addressed a variety of issues, but for this presentation, I'll just briefly discuss the issue of succession, which came up in this claim, as well as this question of what rights are and what kinds of restrictions might apply to the exercise of traditional rights under native title. So where is Gurtja country? Well, it's centered around Delta Downs station, which you can see on the map here, north of Normanton, in what you can either call northwest Queensland's Gulf country or southeast Cape York. And there are arguments for both of those descriptors, but it's north of Normanton around Delta Downs, east of Doomadgee, where David Trigger did his PhD research in the 1970s and subsequently, and south of Kowanyama, where lots of people have worked, but where particularly John Taylor's research was relevant to this claim. So my research with the Gurtja people began in 2010, and I was sort of luckily able to participate in the process almost from the beginning. There'd been various, processes at work and attempts to assert traditional rights, and there'd been some research which was done by another anthropologist or 2 other anthropologists. But I came in 2010 to work on the genealogies for not just the Gurtja people, but neighbouring groups who were clustered and centred around Normanton. And the claim was eventually lodged in 2015. So I did field work over the years before then and subsequent to that with not just Gurtja people, as I mentioned, but the neighbours, Gulthan and Kukach people who are clustered around these pastoral stations. The lay evidence was heard in 2019. It went to a hearing on country on Delta Downs station, which was an interesting experience to hear evidence under a marquee in the bush with wallabies and snakes slithering around, including under the witness stand the day or 2 days before the hearing began. And the expert evidence, as I mentioned, was heard in March 2020, and then we waited for the judgment, which came through towards the end of 2021. And as far as I know, it's the first fully litigated native title claim to succeed in mainland Queensland. But maybe others will have some corrections to that. But they're unusual to go to full hearing in Queensland, and this was a recent successful one. So what were some of the issues that came up in the trial? Well, one of the issues of society and continuity of law and custom were resolved prior to the hearing. And there is I think it's an interlocutory judgment, which you can look at from 2019, which does address some issues relevant to the giving of expert evidence and participation in joint conferences. But in the hearing itself, after those issues of continuity were resolved, the main issues came down to the question of succession, what succession means and how it may be proved, and whether any limitations exist or existed on the exercise of rights provided for under traditional law and custom. So I'll quote mainly from the judgment, which is a pretty fulsome judgment and quotes the expert evidence thoroughly. But these are the legal questions in the, I guess you call it the preamble to the judgment. Relating to succession, the question was whether it was necessary to prove the actual process or other facts to establish licit succession, whether sufficient spiritual correspondence between traditional laws and customs of the extinct and the claimant group or the incoming group as members of a broader overarching society, where the experts disagreed on the indicia of processes of succession, and the question of whether the confidence of claimants in their ability to manage the country and its spiritual forces, the relevance that might be applied to that question. And then, of course, the question of rights and whether those rights should be limited in particular ways, such as the requirement not to exploit resources for personal financial gain. So these are issues which are obviously popping up all over the country, and this is what the judgment heard. So the ethnographic background to the issues. Normanton was sort of neglected a little bit, I think, in anthropological research. Lauriston Sharp, who worked in north of there, whose thesis addresses what he called the Yigorot people, published an article, a sort of infamous article in anthropology in the 1950s, where he dismissed the Aboriginal people south of his sort of primary research field as broken natives huddled on cattle stations or on the fringes of country towns. And I think there was this sort of perception that the impacts of colonisation had been so severe in this region as to shatter people's system of traditional law and custom. Norman Tyndale visited Normanton briefly. He spoke to Rolly Gilbert and one or two other forebears of today's claimants, and has published some interesting remarks about Normanton in his 74 publication. And there was significant language research sponsored by the Institute in the 1970s. Peter Sutton in, I think, 1970 to 72, leading to further research by Gavin Breen and Paul Black, whose work became critical in the hearing. Black worked particularly with a Kurritja man named Rolly Gilbert. And this work in the 1970s, in the early 1980s, in the Bjelke-Petersen era in Queensland, was significant in helping to support and secure the purchase of a pastoral lease, Delta Downs, north of Normanton, which enabled Kurritja people to move back onto that country after a sort of absence of many people, not everybody, where after people had moved into Normanton town after the Second World War, they were able to move back, barely sort of 30 years later with the purchase of this property, which was controversial at the time. Bjelke-Petersen obviously opposed it. There was some relevant research also by Paul Memmott and others arising from the Century Mine development, in the west, and the Century Pipeline transports ore to Karumba. But this research, I think, largely bypassed Kooderja people and country, particularly, I guess, because of Delta Downs. Many relevant informants were living out on the station and working. Delta Downs is an interesting feature of this region. I think it's one of the oldest and largest successful and continuing Aboriginal cattle stations. This is a photo of sunset on the Gilbert River, but the Delta Downs obviously played a sort of central role in the hearing and in the, Kooderja people's lives, in sort of contradictory and challenging ways in the end. But it helped to support, this wonderful vitality of Kooderja people's traditional law and custom. And I was really fortunate working closely with people, as I mentioned, on the genealogies, and subsequently in being able to learn lots and lots more than I expected. So I was surprised, for example, to be recording Kooderja language, which was, predicted to be extinct or to be sleeping as early as the 1980s. It was described as an endangered and dying language, and I found little pockets and people who were proud to be holding some terms and some expressions in Kooderja and could generate them. And just to pay some small tribute to Warren Beasley, whose evidence is quoted extensively in the judgment, who is just a remarkable person, who was born under a tree in Kooderja country in the late 1940s, and just held on to this extensive place knowledge. And I wanted to just briefly, it's a little bit off topic, but tell the story of Warren, or one of Warren's stories about the tried bull. So we were having the hearing on Kooderja country, and the day before the hearing, Warren is a key witness. And he's sort of working himself up to be cross-examined to give his evidence. And he said, "Don't underestimate me. I'll tell you the story of the tried bull." And I made some notes about it later, but he was on a station in the claim area, and he and a mate picked a bull each to throw, and he picked the tried bull, so the bull that other men had tried to catch and failed. And he described, this day before the trial, he described trying to throw and pulling him this way and that, and not succeeding. He threw his hat on the ground to try and distract him, but the bull, he said, wasn't having any of it. He was getting his wind back, and I was getting buggered, and I thought, here we go, he's going to kill me. And you wouldn't have known it. There was a tree there, he says, just this big. I wanted to climb it, but it was too small. So I jumped behind it. I ripped my shirt off and I wrapped it around the tree, and the bull looked at it and thought, here we go, I'm going to get him. I'm going to kill him. And the bull ran straight up to that tree and knocked himself out. And I just chucked a hobble on him, and that was done. And this really prefigured the evidence that he subsequently gave. It was a wonderful little anecdote. So how were these issues resolved in the judgment? What were they? Well, one was the issue of succession. And Paul Black's work was really pivotal, as I've mentioned, in securing the station. And he mapped hundreds of Kooderja place names around Delta Downs station with Roller Gilbert, and published about it in the 1990s. He published this map, which seems to suggest a language boundary, which he describes as a territory here, well to the west of the eventual Kooderja claim boundary, which posed all sorts of issues for the description of what this might mean in the evidence. But it also raised the issue of succession. What is succession? To what extent, are we talking about people coming in and bringing their country with them, or are we talking about another group of people taking over somebody else's country? And the judgment is worthwhile and interesting reading, and finds that the anthropological evidence established that the critical test for whether succession has occurred is whether the incoming group is confident in its ability to manage the spiritual potencies of particular areas of land and waters. And the prescription of some checklist of criteria to establish that licit succession has occurred may involve an inapposite concentration on form over substance. And I think this was obviously a critical finding for the Kurdish people's claim, but is perhaps relevant to other claims dealing with the process of succession, and really finding that the proof is in the this confident assertion and ability to manage the potencies in the country. All right, the second issue is the issue of rights. The right to take resources for any purpose was contested by the state of Queensland, as it's routinely contested, I think, by other respondent parties. Kingsley Palmer, Dr. Palmer, was involved as an expert anthropologist acting or engaged by the state, and he opined, and he's quoted in the judgment here, as expressing the view that Kurdish people's right to use resources was not unconstrained, but had to be sustainable and not in any way greedy. And further, that Aboriginal societies had economies in which exchanges were better characterised as gifts, that the nature of the right, the extent of the right is bound by the context of the economy and the environment, the whole universe of meaning in which the right was embodied. And
Sorry to butt in, Richard. You've got about 5 minutes left.
Great, thank you.
No worries.
So this takes us to what rights are and how we really bridge the conceptual gap and challenge between this legal discourse, which uses words like rights, and what we might understand in anthropology as the exercise of a right. And Nick Peterson's podcast is excellent on this question, which is, I think, available still on the CNTA website. But the literature from this claim area is interesting because it includes some interesting comments in a later article by Sharp and Roth, obviously talking in the lower Gulf about things like markets and traders, which are not common or not supported in the rest of the literature about trade or exchange or gift exchange by Stanner and Thompson, Falkenberg and others. But it points, I think, to the ambiguity and the sort of struggle within anthropology to provide clarity around these kinds of issues. And I'll skip now to the judgment, which makes a variety of interesting comments about anthropology that maybe people might pick up in the discussion. So the judge describes the anthropological categorization of an activity as an exchange transaction involving a method of scholarly analysis of a society and its relationships, which is different from what an economist might generate, or a lawyer applying another analytical perspective, concentrating on the ability of each side to pass good title to the other for the items of property. And at 316, he concludes that the anthropological categorization of the activity of taking resources and subsequently applying them, while informative, cannot be determinative of the legal characterization of a native title right in the language of the common law. And he rejected the anthropological analysis by expressing that the right can be distinct from its exercise, and so on. I think this is a really interesting issue for native title and also for sort of conceptualizations of Aboriginal economic activity and And it again came back down to all the evidence which came out in the hearing about Delta Downs and the work of the enterprise. And the judge makes some interesting comments on how this effort to operate a successful enterprise can be consistent or congruent with traditional laws and customs, including the exploitation of resources of their country under those laws and customs for their communal benefit. And just to conclude briefly, part of the complexity and I think the ambiguity of all of this is that simultaneously to the recognition of native title rights by people such as the Kurraja, we've got international legal instruments like the Nagoya Protocol, which are being legislated in the state of Queensland to require biodiscovery to act based on prior informed consent and mutually agreed terms regarding the exploitation of plant materials. So you've got this kind of uneasy and developing legal discussion of what rights are possessed by Aboriginal people and how those traditional rights might be translated into the terms of the law and the Australian society. And it's not necessarily fully consistent across different pieces of legislation. I think there are questions about the implementation of things like the Nagoya Protocol, which will be interesting and may draw on some anthropology in that it mentions and involves traditional knowledge and benefits. So I'll stop there.